we are providing a webinar on the new proclamation, Navigating the New H-1B Executive Orders, What Employers Need to Know. Can advance the slide. We want to welcome everyone. Thank you so much for joining us today. It's been a whirlwind for the past, 4 days now. My name is Carrie, and I'm joined by my colleague, Miki Matrician. We'll talk today through the recent proclamation impacting, obviously, the H-1B program, and discuss what employers really need to know in order to prepare for the future. As you might guess, today's presentation is for informational purposes only. It does not constitute legal advice. For case-specific guidance, we'd be happy to engage if you reach out to us directly. The session is just general information. Can advance the slide. So a little bit about WR Immigration. Our mission is to combine strategic legal services with predictive technology solutions that allows us to scale and serve high volume immigration programs. This is inclusive collaboration to provide clients with the very best experience. We're proud to have earned international recognitions and accolades that you can see on your screen. And our values really center on creativity, innovation, and compassion, qualities that are especially important to navigate in connection with this proclamation and how to sort of ameliorate the challenges. So here's the roadmap for today's session. We'll start with an overview of the proclamation and the new $100,000 H-1B fee. It's a mouthful, and I'm trying not to say it that much. I might say surcharge instead of $100,000 H-1B fee. Then we'll move into travel considerations, which over the weekend were very chaotic. We'll talk about the national interest exception and how to prepare those and best practices. Then we'll talk about the practical implications in terms of financial and workforce impact. Finally, we'll close with some policy outlooks. This proclamation is forward-looking. We had guidance that we received from agencies over the weekend that, FAQs that indicated that it really didn't apply to current H-1B holders. So policy outlook, and then also government affairs efforts, what employers are doing, what trade organizations are doing to engage and unpack this. And then, each of these areas has important implications for employers and employees alike. So please, if you have questions, you can put them in the chat, and Miki and I will address them throughout the presentation. And then you can always, reach out to us if you'd like to discuss anything further. So with that, I'm going to hand it over to Miki to get into the nitty-gritty of what this proclamation does.
Thanks, Carrie. Yeah, so I want to start off with just sort of the highlights. It certainly has been a whirlwind and, started off with the feeling of an emergency, right? As people scrambled to get into the US and land somewhere in the United States territory or state. And people were going to Hawaii, Guam, Puerto Rico before the 12:01 Eastern on Sunday, this past Sunday. And what was, made it an emergency was it went into effect a little over 24 hours after it was announced. So in terms of the highlights, really the main thing is that this proclamation is a restriction of H-1B workers' entry into the US as of Sunday, unless the $100K fee is paid, and that's the language in the official proclamation. The proclamation is valid for 12 months and leaves room for extensions. And, the purported reason for this proclamation was to combat fraud in the H-1B system, and it cited to exploitation of the H-1B program and specifically pointing to IT consulting firms who are allegedly overusing the H-1B program. What I think is ironic is that really this proclamation impacts all employers in all industries, and likely bring a bigger impact to those employers who are not the mega immigration programs, right? The other thing that was in the proclamation that's not as much talked about because everybody's really focused on the travel component of this, is that it had provisions directing the Department of Labor to issue a regulation increasing the prevailing wages and a regulation to prioritize high-skilled and high-paid workers. So let's dive in a little bit deeper into the 100K fee requirement. So there are basically two main components stated in the proclamation. As I said, it's an entry restriction first and foremost. It requires the payment of 100K for H-1B workers entering the US. And the language of the proclamation didn't distinguish between those who already had H-1B visas and those who didn't. So it looked like it applied to all H-1B workers, which is really the reason for the panic on Friday and over the weekend. The second component of this is a restriction on H-1B adjudications at USCIS if a 100K payment wasn't made for a filed petition. But there is, in a subsequent section, reference to prospective employer and some phrases related to H-1B workers outside of the United States. So even though the proclamation was drafted poorly and the language is very vague, that seems to be sort of the focus of the proclamation. So agency, over Saturday and Sunday, there were USCIS and CBP memos that were issued, and the White House also issued an FAQ which essentially did narrow the scope of the proclamation. I think, the part of the anxiety and the uncertainty that people are feeling is because the agency guidance can be changed really without any notice, right? And the language in the proclamation seems so broad, and that's sort of the dissonance that we are seeing. So, the agency guidance is helpful in understanding a little bit more what the White House intended in the language that is so confusing. So let's go to the next slide and look at who is impacted through the lens of the agency memos and the White House FAQs. So essentially it now says that the 100K payment is for any new H-1B petitions submitted on or after September 21st. It also makes reference to H-1B lottery. And it does say any other H-1B petitions submitted on or after September 21st. So that sounds bad, but there's a subsequent section that says that H-1B renewals are not being impacted. That's a little confusing because in immigration terminology, when we say H-1B renewals, that usually means renewal applications for H-1B visa stamps. But what we think they mean is that H-1B extensions are not impacted. And so they likely are not considering an extension to be a new petition that is the subject of this proclamation. So all this, though, caveat that this is what our guess is, right? Interpreting the confusing language between the proclamation and the agency guidance and the FAQ. That's what it looks like they are attempting to say. And then also CBP, Customs and Border Protection, confirmed in a memo, which, by the way, was published on Twitter or X, saying that anyone who has a valid visa stamp is not impacted, and that it would process H-1B visa holders using its normal procedures. So in that sense, for anyone who is a current H-1B visa holder, nothing has changed. No new fees are introduced. CBP also said the proclamation does not impact people who are beneficiaries of approved petitions or petitions that were filed before September 21st. So that's sort of the lay of the land as it stands. And USCIS also issued a memo confirming the same, that people whose petitions were filed before September 21st are not impacted. So I do think the timing of this is very curious, though, because the proclamation was announced a little over 24 hours before it became effective on September 21st. And that's the first date that people whose cap H-1Bs were approved and visas issued could enter the United States. And, as most of you know, October 1st is the first date a cap H-1B worker can begin their employment, and they can enter the US as early as September 21st, which is 10 days before their start date. Because they now said current visa holders and people with pending or approved petitions are not impacted, it actually didn't block the people that seemed they were originally intending to block. Now in the current guidance, it looks like they're focusing really on the 2026 cap lottery. So that's where we are today. And let's go to the next slide. There still are many, many unanswered questions. So when the White House FAQ says that only new petitions are impacted, what does that mean? Are change of employer petitions considered new petitions? Are extensions new petitions? So as I said, our educated guess is that extensions are not impacted. So then what about change of employers? I think that a generous interpretation of the guidance, all the guidance taken together, would be that H-1B change of employers petitions would not be subject. If we are to extrapolate that H-1B renewals are extensions of stay, and extensions of stay encompass H-1B change of employer petitions. So that it takes a couple of logical steps to get there, but we're hopeful that that's what the administration intended. But it is not stated or referenced anywhere in the guidance from the White House or the agencies that change of employers are not subject. This is sort of our logical several steps that gets us there. And some of our colleagues are still interpreting this less generously because of the uncertainty, right? And they're waiting to see what happens. And some of us are testing the cases out with caveats to employers who really need to onboard their H-1B transfers. With caveats, we are testing some of this out right now. The other category of people we don't really know about is H-1B workers who who are going to be requesting change of status from within the US. Are they impacted? Because the proclamation cited to prospective employment and people who are abroad, if you are changing your status from within the US and not leaving the US, are you okay? That is a question that remains unanswered at this point in time. Let's see, the other one is, for cap-exempt employers, are those impacted? Because the agency guidance refer to the H-1B lottery. And if you're exempt, if you are an employer exempt from the lottery, are you impacted? There's no answer as of this moment to that question.
Mm-hmm. Yeah, and just to tack on to that, Miki, I mean, I think your point about employers testing change of employer petitions and or change of status petitions, thinking through that risk assessment and what could happen. We're filing all of our H-1Bs online through the MyUSCIS platform, and there's no opportunity in that platform to pay the $100,000 fee. And so we, as we test these cases and file change of employer petitions for companies that are willing to take that risk and have thoroughly analyzed it, we expect that in case USCIS does attempt to apply the $100,000 fee to those change of employer petitions or those change of status petitions, that the employer would then need to decide, probably in response to a request for evidence, because it would probably, USCIS would likely issue a request for evidence asking for the fee, or in the alternative, asking the employer to justify why the fee isn't required. And then we get into the national interest exception response. So, I think the point is that we are proceeding, employers are proceeding with change of employer, change of status, just knowing that it could result in a request for evidence, in which case we would need to respond with the national interest exception argument, and or potentially just withdraw the case if there isn't a good national interest exception, and or if the employer just doesn't want to avail themselves to the fee or the program under the fee or with the fee applied. So there's a lot of uncertainty, and there's a lot of sort of contingencies and hypotheticals that we're walking through right now in order to make those decisions whether or not to go ahead and file cases that have uncertain outcomes.
Yeah, and Carrie, I like the point that you're making about online filings too, because what weighs into this is what instruction is the USCIS intake worker getting in the mailroom, right? Are they being told to reject petitions that check off new employment, that box on page 2 of the Form I-129 for the H petition? Or is it just petitions that click off notify the consulate on that page? So, I think online filings is probably a great way to kind of avoid confused mailroom workers, right? Because online you get the receipt right away, you pay the fee, and then that the case was at least accepted online. So, yeah.
Yeah, having that receipt in hand adds a lot, in terms of peace of mind, just having the receipt. The other thing that I wanted to mention briefly is that this proclamation is valid or in force for 1 year. So it actually will expire before the next lottery selected petitions are approved, and the next lottery beneficiaries would be obtaining their visas and re-entering. So if the intention was really to impact next year's lottery, then this proclamation would have to be renewed or extended because it expires before those next year lottery cases would become valid. So that's just an interesting point that this could expire and not impact next year's lottery at all. But I guess that's wishful thinking. Still an interesting point. So let's move on to travel considerations. With regard to travel, we're advising clients to consider, deferring any non-essential international travel. And we've actually been advising this since January, but, now the conditions bring into sharp focus the risks in connection with travel, because whether or not this proclamation impacts a current H-1B worker, we have now seen how the current administration can create chaotic, uncertain, and very costly conditions for employers and employees. So generally, we're not recommending travel. Of course, it's a personal decision. Sometimes it's a business decision. We're already seeing delays at consular posts. The Department of State, I don't think, as of right before this webinar, has issued guidance on how they're going to implement this proclamation, but it'll probably be via PIMS. They'll probably be able to see the fee payment in the PIM system, I would at least imagine. And then there is also confusion at Customs and Border Protection ports of entry. So on Saturday, we actually saw instances of H-1B visas being canceled before the CBP memorandum came out, before the FAQs, because there was so much confusion about how CBP was supposed to be enforcing the proclamation. That has resolved. I mean, we saw people enter on Saturday night and on Sunday without any issue, and people continue to enter at Customs and Border Protection. But again, the situation could change abruptly, and you may have a Customs and Border Protection who's, I don't know, living on Saturday the 20th and still applying those rules. So it is risky. To manage these risks, it's important to update employees with conservative travel guidance. strengthen escalation protocols, maybe have a hotline or a ticketing system or some type of engagement where you can be apprised of emergencies quickly. And then, we think it's more important than ever for there to be tight coordination between human resources, legal departments, and global mobility teams. And you may also want to message to your employees that they need to provide specific travel plans in advance. Because monitoring H-1B employees outside the United States is really more important than ever. And we actually do that. We have a system where we are easily able to track and report on upcoming or current travel. So if folks are, if there is another similar proclamation where we would need to identify people that are outside of the United States, we can do that. And we would recommend having some type of system where your employees can report in, put in travel plans so you'd be able to go in and see who's not here. But Miki, was there anything else you wanted to mention on travel?
No, you covered it. I mean, I totally agree with avoiding non-essential international travel because of all of those reasons and just a really fluid immigration landscape right now. So we can move over to the national interest exceptions. So as we already alluded to a little bit, the proclamation does have a provision that is a carve out for national interest exceptions for people who are deemed vital to the U.S. national interest and does not pose a threat to U.S. security or welfare. It doesn't automatically provide exceptions or provide parameters for national interest. I know the media, I think I saw an article from Bloomberg maybe last night or this morning about the fact that the White House has said that doctors will be exempted. Well, we haven't seen any confirmation of that, but if that's the case, that is some hopeful news to start off with. Interestingly, basically the exceptions are possible for individuals. So that would be the national interest exception application that we would submit. Or it could be all foreign national employees of specific companies or a whole industry sector like, doctors or, hospital workers, university workers, as an example. So who would designate the national interest exceptions? The proclamation says the Secretary of Homeland Security. How do we apply for it? The mechanism is completely unknown at this point in time. Is it going to be handled kind of for cases that are before the consulates? Is it going to be an electronic packet that we send to the consulate like we used to for national interest exceptions for the COVID travel bans? Perhaps. If it's to be accompanied with a USCIS H-1B petition, is there going to be a form? No idea. It may be just a support letter with additional evidence, documentary evidence. So that remains to be seen. We don't know how they've contemplated this process and procedure for filing for a national interest exception. But I think we do anticipate that it would be highly discretionary and subjective. And so, it would be really good to for employers to work with Immigration Counsel to strategize on, specific individuals or roles that might qualify for national interest exception. And how do we identify that? I mean, I think we can look to past, history to inform us a little bit on how we might think about it. The fields that were deemed critical to national interests, like critical infrastructure, national defense, healthcare, scientific research, those may be some. I do think it's a little bit challenging because what's considered to be in the national interest seems to be in flux under this current climate. So, those are some considerations. I guess one helpful reference as I was kind of looking through is, critical infrastructure sectors are listed out at cisa.gov. In the past for national interest exceptions, we used to look at government documents. If there was research or funding granted in specific areas, those were helpful national interest exception documentation.
Yeah, and just to sort of echo that, Miki, I think this is also where your government affairs teams can come in, especially if you as an employer have federal contracts or are supporting critical infrastructure, maybe are a subcontractor. You can get your government affairs teams engaged in to supply evidence. And again, I think that's why it's so important for not just global mobility or immigration managers to engage on these, but also to get legal departments involved, because these national interest exceptions, and Miki, you can chime in, but during COVID, we got really good at making these arguments and securing these national interest exception waivers. So we know how to do them, but we'll just need to be updating our processes and documents and coordinating across departments. So with that, yeah, we can move on to the financial workforce and impact. We go ahead and advance the slide. So when combined with what we anticipate is prevailing wage releveling, and I heard from a little birdie that the new registration releveling rule may be published tomorrow in the Federal Register. But combined with prevailing wage releveling and uncertainty in the lottery process, this new surcharge could significantly affect a company's talent pipeline, right? We anticipate the overall petition volumes could decrease starting with the next fiscal year lotteries, fiscal year 2027, those cases that we're filing next year. As some companies decide that the expense is simply too high. And the burden will fall most heavily on startups, mid-sized companies, and those cap-exempt nonprofit research organizations, which we anticipate will be impacted immediately. And I just want to reiterate what Miki said. There have been reports that some of those cap-exempt organizations may be exempt from this new proclamation, as a sector or part of the industry or sector that they're in. But this fee will definitely have an impact on smaller mid-sized companies that do not have the resource to absorb the costs the way that a larger company can. But even those larger companies that file H-1Bs at a high volume, you bet they're going to be more discerning about which H-1Bs they're supporting. So for many businesses, this increased expense may end up being passed along to clients and customers. So either through higher pricing as a consumer, or potentially through delays on project timelines as companies rethink how to deploy their talent. And this all adds uncertainty to the workforce planning in the years ahead. And we're even seeing employers looking to offshore talent. So we can move to the next slide. Given these changes, companies may accelerate domestic hiring and even investing in reskilling initiatives. Others may choose to reallocate roles to offshore locations to avoid costs. And we expect greater reliance on alternative visa classifications. And we're very practiced at identifying alternative visa classifications because of the lottery, right? I mean, anybody who's not selected for the lottery, we need to identify alternatives. So, we'll put those people in TN status, O1 status, maybe transferring them to an affiliate overseas for a year so that they become eligible for an L1. But, we do think that there will be a brain drain toward Canada, the European Union, and Australia. These companies have more open visa regimes, and we'll probably see global corporations redirect and steer their talent to friendlier jurisdictions. Even internships and graduate recruitment strategies will be reshaped. Employers may not be going after the best of the best in terms of grade point average and the highest performers in college, because they won't be able to file those H-1B petitions on behalf of those most talented people. And we'll, of course, see ripple effects in research and development in the US. I was at a conference a couple weeks ago where European scholars were discussing global talent, and a few of them expressed real enthusiasm for pulling talent from the United States as a result of restrictive immigration regimes to Europe and other parts of the world. So, we may see a bit of a feeding frenzy with other countries pulling talent that would normally be leveraged by US employers. So let's talk a little bit about policy and outlook. I don't want to be too gloom and doom, but it's sort of where we're at. We do anticipate, I think, logic dictates that we do anticipate an overall lower volume of H-1Bs, and specifically for the lottery. Larger firms may continue to file H-1B petitions. And we'll see in the next registration cycle how this pans out. We may see litigation. We may see this fee enjoined or even go away. There are real concerns in terms of rulemaking, because this is a fee that applies to in-country Department of Homeland Security petitions. The employer has to file this within the United States, yet the proclamation applies to out-of-country visitor or travelers, people that are trying to enter the US. So there's some sort of dissonance between whether or not 212F would apply, right, to employers filing these petitions in the US. So there may be litigation. We'll see how that pans out for next lottery. I already mentioned that this proclamation actually expires before October 1st of 2026. So it's not even truly applicable to the next lottery or lottery beneficiaries yet. It would need to be extended in order to do that. We also are seeing already employers and trade organizations organize and attempt to engage rulemakers, Congress, and other decision makers or policy makers at the federal level. So it's important to engage those trade organizations, through your government affairs department if you have one, or directly, to try and get answers and to try and push for a result that is best for you as an employer. We can move to the next slide. So we know that the tech industry and higher education institutions, even foreign governments, are voicing strong objections. Business coalitions like the US Chamber of Commerce, trade organizations like the American Immigration Lawyers Association are lobbying Congress, and even some industry groups are pursuing litigation to block or modify the fee. These outcomes could reshape the enforceability of this new rule. So it's essential to monitor developments. And I think Miki and I are obsessively monitoring these developments. We'll continue to keep you updated as these efforts progress.
Yeah, and I know that there are at least a handful of groups that are planning filing suit very shortly. I think, because of the narrowing of the scope of the proclamation, the emergency nature kind of went away in the immediate short term, it seems to be why the groups that are going to sue are kind of coordinating and being more careful about what they're going to file. But, I think the key thing, and Carrie sort of alluded to this, is that this proclamation was based on a part of the immigration statute that gives the president the authority to restrict people from coming into the United States. But this isn't really restricting entry so much as conditioning the entry based on the payment of a sum of money, right? And I think, the payment of filing fees are generally mandated by Congress. For H-1B filings, in addition to the base filing fee, which goes up to adjust for inflation and such. But, there's the $500 anti-fraud fee that's congressionally mandated. And that anti-fraud fee funds USCIS's Fraud Detection National Security Directorate, right? That does the site visits. And the ACWIA fee is another fee that was congressionally mandated that goes to a program that trains US workers. So, I think the fact that the president just unilaterally signed this proclamation to effectuate this new fee, I think is going to be challenged on that basis. And the other thing is, we think the other reason we think it'll be brought to the courts is that, when the US government makes a huge change like this to their system, it has to go through a regulatory process so that there's input from stakeholders like businesses and lawyers and, the employees, beneficiaries that would be impacted. And that's the whole point of the notice and comment period in the regulatory process through the rulemaking process. And that was entirely skipped, which is why there's this mass confusion, right? Because the proclamation uses language and the FAQs from the White House uses language that don't quite fit into how we normally handle immigration cases. And I think, because of that reason, it's not following the normal process, the administrative process that the government is required to follow, which is why I think it'll be challenged in court and hopefully successfully.
Exactly.
So in terms of what employers should do now, it's really around, getting your arms around the population that is impacted, and I'm sure you're all doing that already. Auditing your data, like Carrie mentioned, developing, in collaboration with your council to come up with a system for tracking your employees' travel plans, whether it be, direct entry into your case management platform with your provider or ticketing system, something along those lines. Looking at your budget, how would this impact your budget? If you are entering people into the cap lottery in 2026, taking a look now, and it's not just the 100K fee impact, right? It's the F1 people who are newer to the workforce and therefore their pay is lower now that we know this administration is really focused on increasing the prevailing wage levels, as we alluded to. These are going to have a real impact on who you're going to want to sponsor for the CAP H1 lottery. And, if you're an international employer, maybe start thinking about whether the business would consider relocating some of these people outside of the United States with the intention of bringing them back on an L1 in a year. So kind of thinking comprehensively and working with your council to figure out how you want to approach and how you want to converse with your business leaders and executives. And then, the national interest exceptions, figuring out once you've identified the people that are going to be subject to the 100K fee, considering, who might start gathering information for that might have the best chance at an NIE. And then, as Carrie already mentioned, staying engaged with groups and your legal counsel. I mean, the landscape is fluid. There seems to be a new change every week or every few days. And it's both in the public policy, published policies that are changing, but also behind the scenes, right? And adjudications trends over time. So I think if you're not already part of a group sharing intel and ideas and strategies, now's a great time to do it. And, we also have a business immigration benchmark collective that you can participate in a quarterly benchmarking survey, and you can get a report that shows where your program fits in comparison with others in the industry. We also hold virtual roundtables where it's a free-flowing discussion about pain points and sharing ideas on how you and others are addressing them. So those are just a few ways to engage and stay on top of all that's happening right now.
Yeah, I like what you said about the benchmarking. I think this topic is something that will be benchmarking very closely in terms of, change of employer petitions if they're going through, change of status petitions if they're going through, and we'll be generous at sharing that information, but we'll probably have a benchmarking roundtable on this topic specifically very soon. So stay tuned for that. There are trade organizations. I'll just throw a couple names out that we know that are engaging and probably going to sign on to some type of challenge, including the U.S. Chamber of Commerce, National Association of Manufacturers, the TechServe Alliance. So there are a number of trade organizations that are supporting this, and our recommendation would just be to work with in-house counsel and or your government affairs group to identify the appropriate organization, because normally how it works is that these organizations will sign on to like a class action lawsuit, or they'll sign a petition to submit to members of Congress to hopefully affect some policy change. And as Miki said, I think at the end of the day, this rule impacts U.S. employers. U.S. employers are required to pay the fee inside the United States, which is not something that I think 212F would be able to justify. So, and 212F is sorry, I keep on saying that, but it's the section of the Immigration and Nationality Act that gives the executive branch the authority to make entry restrictions for national security and public safety purposes. So I think we can go into some of the Q&A now. I do also think that a lot of these questions were probably answered as Miki and I spoke, but we can go through them and pick some of the ones up that were answered.
I think the burning question on everybody's mind is, are change of employer petitions subject to the proclamation, and are change of status from within the U.S. subject to? And we kind of discussed it, but it's just this the language that is unclear, that essentially the White House and the agencies have not confirmed. So again, the White House said that H-1B renewals are not impacted in their FAQ. And renewals are not something that we refer to as extensions, but we think they mean extensions are, we think they mean by renewals that they're talking about extensions. And then if we take an additional logical step that extensions encompasses extensions of stay, which change of employer petitions often are, then we could guess that maybe they intended to exempt change of employer petitions. But all this is just speculation. And I think firms and employers are testing this out right now.
Yeah, and change of employer is another word for H-1B transfer. So when we say change of employer, we mean H-1B transfer. So like Miki said, we're testing those cases right now. And if you are with an employer that's willing to, absorb the risk, they could proceed and see what happens. So I had a question about a contractor. There's an employer or company that's currently using a 1099 H-1B that's working for a consulting company, and they're asking about bringing this employee on as a direct direct employment situation, or this contractor on for a direct employment situation. And this situation would be covered by the H-1B change of employer, H-1B transfer. So unfortunately, this is one of those wait and sees. We're testing these cases now with employers that are willing to move forward, or really that don't have a choice. So we should really know on these premium processing cases in the next 15 to 20 days if these are going through without challenge. Cap-exempt employers, for now, it does look like this impacts cap-exempt employers. And those are typically new employment situations or change of status situations, because they do not have to wait and engage in the lottery. As Miki indicated, there have been news articles of sectors of the economy that will be exempt from the rule, like, for example, the healthcare industry, which files a lot of cap-exempt H-1B petitions. It is TBD, more clarity, in the next couple of weeks, as these petitions are adjudicated. So something that we mentioned that is raised a few times in the Q&A is the prevailing wage releveling. So the way that we anticipate it's going to work for H-1Bs, and I did hear that will be published in the Federal Register tomorrow for no comment, is that the wage level 4 will be given more priority in the lottery, so for potentially like 4 chances, whereas wage level 1 respectively would only be given 1 chance in the lottery. In the new prevailing wages that were published on July 1st, those are valid for the duration of the year, but the different 1, 2, 3, 4 levels is what we think that lottery registration is going to parse out and use for priority of lottery chance. And so we don't think it's going to necessarily impact perm. There would have to be a Department of Labor, a new survey, essentially, and publication of Department of Labor prevailing wages.
There's a question about whether the application fee, I guess they mean the 100K fee, is a one-time payment and any refundable terms. So I think there was initial confusion when in a press release or press briefing, there was a comment from the White House around how this is going to be an annual fee. They have since confirmed that it's a one-time fee per person, is what I think they meant to say.
Good clarification. There was also a question about the 100K fee not being applicable to the next filing cycle effective April 1st, and wanted an explanation. So, I mentioned that this proclamation is in effect for 1 year, so until September 21st of 2026. Lottery cases in this next season that are filed on April 1st will be valid as of October 1st of 2026, so 10 days after this proclamation expires. So if the administration intended for this proclamation to apply to next year's lottery, then it will need to be renewed or extended.
There's a question about if we have FY26 cap change of status or consular notification petitions still pending, are they impacted? So any petition that was filed before September 21st of 2025 are confirmed to not be impacted by the 100K fee.
Here's a question about whether or not the proclamation impacts spouses, H4, and those cases are not included, or those individuals are not included in the proclamation. So this fee only applies to the principal H-1B.
There's an interesting question. Can the Trump administration do this for other visa types on a whim? For example, could it impact O1s next Saturday? Let's hope not. You know, I guess the situation is the president has issued proclamations, whether they are, you know, within his scope of authority or not, and that's precisely the reason that, you know, these can be challenged in court if, for example, the administration decided to impose a new fee on O1s as well. That's one of the bases for a potential challenge to the proclamation, is that any fees like this would be subject to congressional mandate and not should not be permitted to be effectuated with the stroke of a pen.
Yeah, I think it does, you know, add some gravity to those decisions on whether to travel. You know, this situation on Friday night caused such chaos. And so, you know, we're really encouraging folks to be consider more carefully whether or not they need to leave the United States. There's a question asking, do we know of individuals with previously approved H-1B petitions who have been issued an H-1B visa stamp after the proclamation and have been admitted by CBP without any problems? We have had reports, you know, we've benchmarked across our practice, and there have been reports of H-1B visas issued and travelers entering through CBP. You know, if folks can use pre-clearance, that is advisable. Of course, not everybody is in a place in the world that has pre-clearance, but you know, pre-clearance will often provide some peace of mind. Reading some of these questions.
We have a lot of questions. Thank you, everybody, for putting them in the chat. I'm trying to weed through the ones that were already answered. Let's see.
Oh, let me mark those as done. There's one here. Do you believe L1 adjudications could get more stringent, especially blankets at consulates, since many employers may now look at L1s as an option more than before? And I think, yes, I think the volume of Ls, TNs, E3s, and other visa types is going to increase drastically if this fee is sustained. And so I think just based on that volume, consulates will get more stringent on adjudication because of the volume that they're receiving.
There was a question asking us to confirm about the updated wage levels coming shortly. Yes, so the proposed regulations are, we're hearing that it is due to be published tomorrow, and it is expected to be a 30-day notice and comment period, after which it can be finalized. So it looks like they're trying to institute this before the next cap cycle. And I think there was earlier a question about whether the new, you know, proposed prevailing wage regulations that are due to be published tomorrow, and then the subsequent ones that where the proclamation is calling upon the Department of Labor to publish, whether private wage surveys would be, you know, continue to be acceptable as it is now. We don't know at this point in time. In Trump 1, when the administration increased prevailing wage levels. I think it was effective maybe October or something like that in 2020. That was an instance in which private wage surveys were still being accepted at that time. Not sure if that informs how they will handle it in the future, but that's how it was in 2020.
There's an interesting question here. Could any of these fees be passed to the employee should they choose to leave the company after the fee has been paid for? So oftentimes in our practice, we get questions from employers asking if they can have a clawback agreement to claw back some of the fees if the employee leaves, or like a liquidated damages or promissory note. And it's a really interesting question here because some of the H-1B fees cannot be clawed back. And that's due to congressional intent, right? I mean, it was in the legislation or inferred in the legislation or in the legislative history. If fees are truly an employer side fee or if they could be shared with the employee. And this proclamation says nothing about that. And so I think it's a really interesting question. Had this fee been part of a congressional act, we'd probably know the answer. We have 2 minutes. Miki, any last comments or any last questions that you wanted to answer?
Yeah, just really that, this lack of clarity is really creating a lot of anxiety and uncertainty and frustration. We're all right there with you. We'll share as soon as possible. There are any updates that come out, we will share. And I guess, community is really a good thing to lean on at this point in time, and join our benchmarking collective, which is a group of global mobility professionals and HR professionals across industries and across sizes, where people come together and just workshop their issues and problems and see how others are handling certain topics. So join us, and thank you so much for being here.
Thanks, Miki. Yeah, I think we have 600 in that benchmarking collective now. So it's a fantastic group to get more information as to where your program is situated and how others are dealing with this surcharge. So yeah, thank you, everybody. Thank you so much for joining us today. And we hope that this was helpful. Please reach out if you have any questions.
Thank you.